637-0094. That's our number. I wanted to get Attorney John Brown onto the show here. Good morning, John.
Good morning, Chris.
So I was trying to think of how to explain your background, and I don't know if it's an oversimplification, but you kind of wrote the book on procurement.
For Guam.
For Guam, yeah.
Yeah.
And so, that being said, I know you've been following current events, and I don't know if you want to speak specifically or generally on the way that you handle procurement during an emergency. And so we're now in a public health emergency. So, just really wanted to go to an expert, and I just want to give you the floor and tell me how it's supposed to go.
Well, you're right. Answering a question about procurement in the abstract is capable of misleading very easily, because so much of the law, not just procurement, depends on the particular facts. But in terms of outlining the law, there is, for general procurement purposes, an emergency procurement process that the procurement law prescribes, actually. But then it turns out that there are other laws that are applied. So it's not just the procurement law that you have to be mindful of. The procurement law has a very horribly written emergency procurement statute that fundamentally is meant to be universal, but there's a very specific definition of emergency procurement that sometimes is a big issue. But in this case, I don't think anybody is questioning the validity, and I certainly wouldn't, of the declaration of a public health emergency. That then gets us away from the procurement law. But let me just say that in the procurement law, in that emergency procurement part of it, it's a very complex, as now written, provision. It bounces around everywhere, but the bottom line in the procurement law, emergency procurement section 5215 of the procurement code, says that emergency procurements have to have this and they have to have that. They've got to do this within certain time frames and all of that. But there's a bottom line, provided that that emergency procurement shall be made with such competition as is practicable under the circumstances. So from the procurement law standpoint, providing competition in your pricing of your purchases is a means of making sure the government gets good value. Because what we don't want is to have expenditures fraudulently or misapplied. That's not good for us, not good for governance, not good for you and me and everybody listening, to have their money spent willy-nilly. And so that's what the procurement law is trying to do. But I don't think that the procurement law is going to be the prevailing force in this. There are two emergency laws that are applied generally to health, one more specifically than the other, perhaps. There's a civil defense law that makes the Civil Defense Authority on Guam responsible as a center for us for dealing with primarily military, but not entirely, also natural disasters situations. It dovetails that was written back in 1952, by the way, or passed in 1952. Okay. So that's been around a long time. Then more recently, in 2002, there was a public health emergency law that was written. Both of them are fairly well overlapping each other, and to the extent that they are inconsistent, it creates some confusion as to what exactly is the source of the authority for doing something. Not even the governor can just do whatever the governor wants to do. Nobody has the right to do anything unless there is an authority given to them for that right. And the Organic Act is, of course, the starting point, but then there are all other statutes as well. So it gets a little confusing, and then once you find the law that would be applicable in its broad terms, is it applicable in its exact application to the facts there. For instance, there's been this question about a forgery of a digital signature.
Right.
And I see in the paper this morning that the governor is saying, and I'm not disputing this. I'm just saying that these are the forks in the road. That it's plausible that the director didn't remember authorizing that one. Well, yeah, that is plausible. And until we can decide what is fact from what's plausible, we shouldn't jump to any kind of conclusions.
I mean, it's also plausible that she didn't forget.
That's what I'm saying.
John, so I know you're a sharp guy. You're paying attention. You're reading. You're watching. I just want to get your take on this whole situation with this procurement, because just outside looking in, I want to bring in somebody who knows what they're talking about, and obviously, you teach procurement. You've been in this game for a long time. So how does it hold up? We've asked Lieutenant Governor Josh if this passed the smell test. He said red flags. The procurement oversight of the legislature, Senator Sabina Perez, said that it doesn't pass the smell test, and she specifically referenced the use of Linda DeNorcy's digital signature without her approval or knowledge or remembering or whatever the situation is now. So yeah, what is your take? Does this, based on what you're able to glean from media reports, does this emergency procurement that we're seeing pass the smell test?
Well, the smell test isn't a factual test. It's just that it doesn't smell right. But, you've ever eaten a durian? Smell isn't the ultimate test. And it's one of the first things I teach in the first day of teaching procurement law is that the procurement law applies to a lot of things, but not to everything. And there are competitions and such as that fall outside the scope of the procurement law. But even if it's within the scope of the procurement law, there are methods of enforcing the procurement law. And if you don't elect to use those methods, then there's no enforcement by the procurement law. For instance, procurement law sets up solicitation rules. You have to solicit before you buy. You have to do market research. But it suspends that in the case of an emergency. As I mentioned before, as long as there's competition, it really satisfies the fundamental need of emergency procurement. But there's even something further than that. Suppose you didn't do any of that and the procurement was made, how are you going to enforce it? Because the only people, the government can't enforce its own rules to benefit a different kind of an outcome. The only way a procurement can be challenged is by a protest.
Right.
And a protest can't be brought by just anybody. It has to be brought by a actual or potential bidder. And so suppose we have some of those out there that didn't take part in this. They didn't protest. And there's a timeline. If they don't protest within that timeline, then there's no right to protest. So it's not everything. It's not as onerous as people like to think it is. And in this case, if there was a case for violating the procurement law, it hasn't been raised by a protest within what I think is probably the time. I mean, you have 14 days from the time that you knew or should have known of the facts by which you think there might be a reason to protest. Well, the facts have been bounced around in the paper for weeks. The procurement law isn't the issue here. The procurement law, the issue I think is going to arise under the health emergency procurement rules.
But how can you file a protest if a contract wasn't signed? Would a contract need to be signed and then you could file a protest?
Yeah, because according to the Attorney General's office...
No, stop.
Okay.
Stop. Contract follows solicitation.
I see.
And the protest is of the solicitation. So the fact that it didn't it wasn't, you're claiming it wasn't signed, that changes from a solicitation rule to a rule it may relate back to that, but a contract dispute. Did you actually have a contract? And that narrows the numbers of participants in that dispute. It's a needle in a haystack when you go looking for this stuff. And everybody sees the haystack and think, well, it's in there. Okay, you got to find it. You got to find it exactly where it is.
You find it.
Yeah.
I don't have my glasses.
Yeah, I'm sitting here with mine on, and I can't even read with them.
Mm-hmm.
So, John, I guess, because we got a few other, I want to ask this, and it kind of seems that, I don't know if it's just, Lord knows we have problems with the procurement, right? But there's just so many different things that we haven't been able to, I guess, wrap up with procurement. Like, we've got the protest of the senior meals. There's the, protest on the prison meals. So I guess just generally speaking, is it really that complicated? Because, the governor has said, we need to overhaul procurement. And she cites all these different examples of us not having anything firmly in place because of protests and stuff. So is it really that complicated to follow the procurement law, or is it so problematic that it makes it impossible for the government of Guam to do business with people?
Let me just say, it doesn't matter how you write the procurement law. There's always going to be rooms for judgment calls, rooms for mistakes to be made. Procurement has been going on since the days of the Romans, and before that probably. And so there's always dispute about that. But you don't shut down the whole thing just because you have disputes. The whole purpose of that is to intervene in those disputes and reach a result. Just resolve the dispute once and for all. So, could it be improved? Absolutely. I mean, for the last 2 or 3 or 4 legislatures, I've been involved in trying to get the beginning of a broad procurement reform bill passed. It was vetoed 4 times or pocket vetoed, absolutely vetoed by the last administration. So it never got to the light of the day. One of the things that has in it is a emergency procurement reform, because as I said, it's woefully written. And that's been sitting in our legislature here for a while, and Senator Paris has taken a really good interest in procurement, but of course she's got a full plate too. Right. She attended the procurement classes. Excellent student. She picks it up very well. She understands what we're trying to do. But you can only make it do so much, and if you broaden it too far, then you kind of lose its focus. So it hasn't gone anywhere at this point. So I agree. There's a lot of room for reform. I've put a lot of work into that in the last few years, but it hasn't found any traction.
I did want to ask. There was something that the Carlo Branch had mentioned. I believe it was yesterday we talked to him regarding. We were talking about this whole procurement for the isolation / quarantine facilities, and he was saying that under Title 10. When it gives the governor these emergency health powers, these superpowers when it comes to procurement.
Yeah.
Is that
okay.
is that correct?
The Title 10, as I said, the procurement law is not the only law. Title 10 is another law. This is the public health emergency procurement rules, and there's another one more or less in the civil defense, not civil service, civil defense procurement rules. They're not procurement rules, but it has a emergency procedure in there. But the emergency powers, again, you have to look at them closely. And so, what are the emergency powers under the health emergency? Says that the governor may, through an executive order, suspend the provisions of any. And this is where it gets complicated. What can the governor suspend? Anything? Any and all? No. Only the regulatory statute prescribing procedures. Well, first of all, regulatory statute, I've never seen that phrase. I mean, a statute is a statute, and it regulates things. That's why you have statutes. So I don't know if this is a particular kind of a thing. So already we're being into it. Well, now, wait a minute. What can she suspend? A regulatory statute prescribing procedures for conducting local business. Well, what statutes do we have that prescribe procedures for conducting local business. What? We don't have any that I'm aware of. Fraud things, health things, but they have to be pretty carefully defined in order to provide notice to the public as to what are we talking about here. So this one already kind of raises a little bit of a red flag about, well, what can be suspended? Because it is prescribing procedures for conducting local business or the orders or rules and regulations of any governmental arm agency. But okay, so that's the beginning of it. And then there's even a further qualification on that. It says, to the extent that strict compliance with those rules would hinder necessary action, including emergency purchases. There's your procurement provision. And so to the extent that strict compliance, well, the procurement law, as I said, it's got in the emergency procurement part, has a lot of conditions about notices and who's got to make declarations and who can do it and when you got to do it and for how much can you do it. But as I said before, there's a provision that says, provided that emergency procurement shall be made with such competition as is practicable under the circumstances. A very reasonable standard, but it's not specific. So what is the procurement law provides a lot of excess stuff in it, but it seems to say, but if you boil it down to and you give competition, so did the government give competition? I don't think you can ignore the procurement law simply because in its strict application of every part of it, it gets kind of cumbersome. Because there is a way to cut through all of that and just say, well, we've done, time was short. Time was really short. This was a really severe, it's an ongoing severe and nasty emergency. Can't disagree with that. But the procurement law says at least you have to provide competition. And did you? Well, again, looking at the papers, it appears that the governor's office did make a overture to the Hotel Association, because what they weren't acquiring books, they were acquiring hotel rooms, and evidently some discussion with that. They identified 3 or 4 different hotels. Well, the procurement law doesn't require that every possible bidder get approached and be offered. It does require that you make as public as the solicitation as you can in the circumstances. But even if you've given that some of the notice, you only have to get as such competition as will give you the best price. That doesn't mean getting every hotel on Guam. It means getting 4 or 5, right. 3 or 4. Mm-hmm. And bottom line for some of the rules in procurement are you have to get at least 3 quotes, or you have to ask for 3 quotes. Getting them is something else entirely. So it's not. There's a rule of reason here, and the procurement law understands that. So the very first section of the procurement law sets out some principles and said, if when you go to apply this law, these are the principles that guide you. One of them, major one, is that you have competition. So if you've satisfied the competition rules, you basically satisfied the intent of the procurement law.
Okay.
Wow, thanks for that TED Talk. I mean, yeah, that's why we wanted to get you on and give you the floor. Mm-hmm. And that was, for all you procurement geeks out there.
Yeah. Well, I mean, it sounds like the governor does have some superpowers under Title 10. She made the effort by reaching out to GHRA, Mary Rhodes, in trying to find quarantine and isolation facilities amongst the hotel groups. And I guess these hotels, it appears, had stepped forward because other hotels were like, hell no, we don't want to have a quarantine in our hotel.
Yeah, well, that's it. There's other rules. The principles, though. The principle is that you have to have safeguards for a procurement that has integrity. And again, if you went out and you sought solicit competition and you got adequate competition, that's what's really important in the first instance. But if you're treating, because another one of these principles is that you treat everybody fairly and equitable. Mm-hmm. So if you've done everything except treat people fairly, you've dealt with preferred customers, then you haven't completely satisfied the fundamental principles of procurement.
Mm-hmm. But who should be handling procurement issues? Should it be the chief procurement officer of the government, or just whoever the governor says she wants to handle it?
Well, the CPO, Chief Procurement Officer, has the overall responsibility for the whole territory to conduct or supervise procurement of all supplies and services. A lease of real estate is a supply under the definitions in the code.
Right.
So she has supervision of that, if not the carriage of it. Certain agencies are given the power to procure, their own power. They can go out and conduct the procurement. They have to do it in accordance with the procurement law, but they can do it. They don't have to go through the GSA. So I was about to run into some weeds there, but
I was just curious, is that the responsibility of the legal counsel to go out and negotiate?
From what you're saying, it sounds like the chief procurement officer,
or if it's the chief procurement officer,
should have the final say.
To be doing this.
I don't think that the governor's office is the appropriate person, because under the health emergency procurement, this is given the charge to the director of Department of Public Service.
Public health?
DPH, public health. Yes,
yeah.
Public health administration. They are given the authority to execute this health emergency under Title 10, Chapter 19. So it's their carriage. The governor, of course, can instruct the head of that agency, but ultimately it's the head of the agency's call. And having the governor's personal attorney go out and do this is a bit presumptive. Now, there's nothing preventing them going out and finding out sources and that sort of thing, and letting the public health director know about that, but should not take direct part in doing it, because that's not an authority that was granted to the governor. And again, it's badges that count. And particularly the governor, because there's some of these provisions in the law that talk about the authority to do this, and includes the governor. The governor, by definition, is an official of the executive branch. Is the head of the executive branch, and that makes the governor's office an agency under definitions of what is an agency and that sort of thing. So they all are subject to this authority, and there's several cases from the Guam Supreme Court that says you can't assume your authority if you're part of the executive. You have to identify exactly where it is. You have to point it out in the law. It's not my job to go out and tell them you don't have the authority. It's their job to point out where their authority lies. And the governor's tried to do that, but got a little bit coy with, as I said, the full extent of this emergency power.
That's really interesting, John. I mean, wow. So you're basically saying that Linda DeNorsi
has the superpowers.
Has the superpowers, not the governor, not her legal counsel.
During a public health emergency?
Because it is the Public Health Emergency Powers Act, right?
Yeah. Yes, that's right. Again, the governor has persuasive powers and can use those persuasive powers. But the person who signs off on it is the director.
Who has
whether she knows or not, digitally. John,
well,
yeah, that's something for us to get into. John, I appreciate your call so much. We're at the top of the hour.
Thanks for the clarification.
Yes.
Sure.
And let me know when you got a class. I think I want to sit in with one of these. This
yeah.
pretty interesting.
They're booked out, and of course we don't have classes.
You don't have online?
Look, I'm 71 years old. What is an online?
All right. Thank you.
You bet.
Thank
Take
you.
care.
That's Attorney John Brown. He wrote the book on procurement, and he definitely had some very insightful things to say.
Mm-hmm.
And I
got from that Linda DeNorsi has the superpowers.
Right, not the governor. That's pretty interesting. And I mean, it kind of makes sense, and we kind of heard this before.
During a public health emergency.
Because it is the Public Health Emergency Powers Act, right?
No, it's
something-
it was the Title 10 Emergency Health Powers.
Yeah, that
There's
one.
like so many different provisions in there. I'm not an attorney, but
All right, so
he's
it's
the
a-
one who Emergency Health Powers. Title 10, Chapter 19, Emergency Health Powers.
Right. And so it is 8 o'clock. We're KUAM FM. I got you, Guam. We're going to do news. We got Ed Byrne from Department of Administration.